Companies that have worked on compliance with the General Data Protection Regulation of the European Union are definitely better prepared to comply with the California Consumer Privacy Act than companies who have not. I feel sorry for those of my clients who have a domestic focus and who were spared by the GDPR only to now find that they have this much more rigid, prescriptive, and intrusive law to comply with, which may come, particularly if we get a right of private action, with much more harsh enforcement. And companies who've already worked on GDPR typically have a better sense of what systems they're using, what vendors they have. They can send out communications to vendors more quickly. They can find what data they have better to update their data privacy notices. They have probably some experience with data subject access, deletion, and portability requests, which are also going to be coming forward under the California Consumer Privacy Act. And therefore, they are generally in better shape. They typically have a governance program, accountability. They have people in their company who are in charge of privacy, and this will make things easier. But the CCPA, the California Consumer Privacy Act, is not anywhere close to being a mini GDPR, as some have called it. It has nearly as many words. The GDPR weighs in with 30,000 words, but it has a lot of stuff that is not in the California Consumer Privacy Act, such as data protection authority organization, coordination within Europe, filing requirements, consultations, produce accountability documentation under 5.2, 24, and 32 under the GDPR. We have various paperwork and formalistic requirements that the GDPR imposes on companies, which California companies also have to grapple with, but under many other laws. The California Consumer Privacy Act is not an omnibus law. It's one of literally hundreds of laws that we already have in California and on a federal level that companies have to comply with on top of all these other laws. So companies that sometimes come to me that say, well, we're already doing GDPR, so we don't have to do that much, is not probably an accurate assessment of the situation. The California Consumer Privacy Act is in the tradition of California and US privacy laws that focus on a particular problem, harm, situation, sector. It is broader than many privacy laws that we've seen before, but it is trying to address perceived harms and threats associated with sharing of personal data by anybody in the industry. It is broader, it's not a sectoral law, but it is focused on data sharing with 10,000 words and these super restrictive requirements, whereas the GDPR tries to govern everything else relating to data and is really a data processing regulation rather than a privacy law, because it is not that focused on individual privacy harms. It just generally tries to limit the amount of data that is being processed, how long it is processed, for what purposes companies have to justify to process personal data. All that is not the case under the California law. The California law just puts some rigid restrictions and individual rights into effect that will limit the amount of data that companies can share and use and collect, and that is a different focus. And so I would say to all the companies that have done a good job on GDPR compliance, you're in good shape. You're in better shape, you're ahead, but there's still work to be done.